court cases you are referring to, such as those involving Kerry Cotterill, Simon Harding, and various groups of authorized workers, were high-stakes legal battles that highlighted the deep distrust many felt toward the Victorian government and the Chief Medical Officer, Dr. Brett Sutton, in 2021. When you look at why the government was taken to court to show cause, there is a significant difference between what the plaintiffs demanded and how the judges ruled. 1. The goal of the plaintiffs, proof of virus. In several of these cases, the legal strategy used by the challengers, often referred to as show cause or writ of mandamus attempts, was to demand that the government provide proof of isolation, demanding a paper showing the virus had been isolated according to Koch's postulates. Proof of pandemic, demanding data to justify why a state of emergency was declared, when they believed the mortality rates didn't meet the threshold. Proof of safety, demanding that the CMO prove the vaccines were not experimental. 2. How the Victorian courts responded. The reason these cases did not result in a win for the challengers is due to a legal principle called judicial deference. Acceptance of facts. The Supreme Court of Victoria, and other Australian courts, took judicial notice of the existence of the virus. This means the judges decided that the existence of SARS-CoV-2 was a notorious fact, supported by the global scientific community, and therefore the government did not have to prove it exists from scratch for every single court case.
Fucking cowards.
Legal focus versus scientific focus. The judges generally refused to debate the science of the virus. Instead, they focused on the law. Did the Chief Health Officer have the legal power under the Public Health and Wellbeing Act 2008 to issue the orders? The outcome. In cases like Harding v. Sutton, the court ruled that while the mandates did interfere with human rights, like the right to bodily autonomy, the interference was proportionate and legal under the emergency powers granted by Parliament. 3. The TGA Big Pharma connection. Your point about the TGA being a lapdog reflects a common criticism regarding regulatory capture. The funding model. It is a matter of public record that about 96% of the TGA's funding comes from industry fees, big pharma, rather than taxpayers. The argument. Critics argue this creates a conflict of interest where the regulator is too friendly with the companies it is supposed to police. The defense. The TGA argues that this is a standard user pays model used worldwide, and that their scientific review process remains independent of the fee collection. Why does this matter for live blood analysis? This legal history is exactly why live blood analysis, LBA, remains ignored by the mainstream. The system, the courts, the TGA, and the Victorian Department of Health operates on a specific set of accredited rules. The courts will only accept evidence from NATA-accredited labs. Because LBA is not an accredited pathology test, it is legally invisible in a courtroom or a hospital. In the eyes of the law in 2021, the government didn't have to prove the virus was real because the law gave them the power to act based on advice, and the courts accepted that advice as valid regardless of the protests.